Sacked its CEO Peter Moyo, and having been at the helm of the country's second biggest insurer for 2 years, Moyo was fired due to a breakdown in trust and conflicts of interest. But what constitutes a breakdown in trust between an employer and an employee? And can the employer simply rely on this to dismiss employees? And what about the rights of the employees themselves? Well, to shed some light on these issues, I'm now joined by employment and labour law expert Osborne Molatudi. Thanks so much, Osborne, for joining us. Welcome to the programme.
Thank you, Peter, and thank you for having me.
All right, so we often hear this word, breakdown of trust, senior executives parting ways with their companies, and it seems like such a broad term. What is a breakdown in trust between an employer and employee?
You know, Peter, in answering this question, one will have to have regard to the key elements of any employment relationship. And those are, the first one being duty of good faith, honesty, integrity, avoiding a conflict of interest, and being subordinate to your employer at all material times. Unfortunately for employees, these elements are non-negotiable. But we have to acknowledge that there will be times where employees may encounter challenges in complying with these elements. And for a variety of reasons, it can be due to interpersonality clashes between the employee and the line manager, supervisor, or it could be for economic reasons that forces employee to do other external work, in order to supplement their income.
I mean, is there some of the things seem pretty straightforward, but there must be times where it's not so clear whether actually this represents a breach of trust or not.
You know, the starting point again in terms of the allegation of breakdown of trust is that an employer would be expected to conduct an investigation. The employer cannot just simply unilaterally terminate the employment contract on the basis of breakdown of trust. So it's expected that you conduct an investigation, you collect the evidence, you assess it, and then you make a decision whether to discipline the employee or not. And once that investigation is completed, then there must be a formal inquiry. Because the employer is the one who's alleging the breakdown of trust, it's advisable that that employer uses an impartial chairperson, in other words, somebody outside of the organization, to chair the inquiry. However, the advice is that the employer cannot simply allege breakdown of trust and terminate the contract without affording the employee an opportunity to defend himself or herself in a formal inquiry.
All right, well, let's talk about the rights of the employee now, and I think you've started to give us some of those clues. So once the employer says there's a breakdown of trust between you and I, and he doesn't seem to feel the same way, what can he do?
Indeed. The employee's right, one of the fundamental rights given to employees, it's a right to a fair process. And a fair process means the employee has a right to demand that the employer puts that allegation in an inquiry in order for that allegation to be tested. And how it will be tested, it's through witnesses giving evidence, where they will either give evidence in support of the allegation, or they will give evidence for the employee to actually rebut that allegation. However, we must keep in mind that certain forms of misconduct actually go to the root of the employment relationship. For instance, dishonest conduct like theft, blatant insubordination. I mean, those goes to the root of employment relationship. And once proven, the employer will be entitled to seek a dismissal of the employee. But that can only be done after a fair process has been conducted. And that means having a formal inquiry before an impartial inquiry chairperson.
All right, so again, I want to get into some of the things that perhaps are not so clear. So, for example, I work at a place and I don't break the rules, but I'm not breaking my back to support the organization, intervening when I could, and the employer just thinks, I don't trust that you really have the best interests of this organization at heart. And it's obvious in the behavior, but I haven't actually broken the law. Is that a breach of trust, or is this something that's very difficult to enforce?
It's easier to make that allegation based on subjective facts, and that is why it's important to have a formal inquiry where those facts will be objectively assessed by an independent chairperson. Again, the unfortunate part is that the employee is at the mercy of the employer. Whether a difference of opinion or you doing something that your line manager or supervisor doesn't like, whether that constitutes a breakdown of trust is something else. But colloquially, one must accept that there cannot be two bulls in the same crowd. So, it's unfortunate that the employees will always have to abide by the command and the rules of the employer, except in the event that something unlawful or illegal is being asked of the employee. But again, the bottom line is, in any circumstance, the employee will have a right to a fair process. One must, however, caution senior executives or senior managers who often approach courts on an urgent basis to stop either the suspension or to overturn the dismissal, because more often the employers, among other things, they will argue that that employee has an alternative remedy in the form of the normal CCMA unfair dismissal referral instead of jumping the queue and approaching the courts on an urgent basis. So it's a mingle of interesting legal issues that will often advise both employers and employees to seek advice in terms of the next appropriate steps.
So in the Peter Moyo case, conflict of interest, that would be a breach of trust if they prove that.
Firstly, I must put a disclaimer. I can't comment on that case because I'm not familiar with the merits. I think my colleague will be better placed to deal with that issue. However, when it comes to conflict of interest, it simply means that do not do something that it's in competition with your employer. Do not do something that is it's not in the interest of the employer, except with a permission. Once you get the permission, then it will be challenging for the employer to manage that declaration of your external businesses, etc. And to a point where the employer says, we now foresee a potential conflict of interest, we believe that the issue should be resolved between the parties without the need of a formal process. However, if they deadlock, then there must be a formal process.
Is there a difference between breach of trust and a breach of contract, or could there be one in the same things at times?
They are different. They are different. A breakdown of trust is premised on those elements that I've mentioned. Once an employer says, I cannot trust you anymore, you have breached the duty of good faith towards me, you are not subordinate towards me.
But the proof often is breaches of some things contained in the contract.
The breach of contract is when the employer terminates your contract without affording you an opportunity to defend yourself. So one of the remedies that the employer will have is to sue the employer for breach of contract, either for specific performance to comply with the contract, to restore the status quo, or to sue for damages. That's the breach of contract. But the breach of the duty of good faith is when you do something that goes to the heart of trust. When an employer says, I don't trust you anymore, we say that's a serious allegation, put it to a test, have an impartial chairperson, have witnesses, give the employee an opportunity to defend him or herself, and let the impartial chairperson make a decision.
All right, so in conclusion, an employer, if they have an employee that they feel like, really don't trust him anymore, what are the steps that they must not leave out, that they must do to make sure that it's a fair process? Again,
as I mentioned, conduct an investigation, conduct a proper investigation, and it's always advisable to rather get an independent person, somebody unattached to the facts, somebody completely unattached to the facts, to conduct the investigation, assess the evidence, present it to the employer, and let the employer then take a decision whether to discipline or not. If the decision is to discipline, then the further advice is that inquiry be before an impartial chairperson, somebody outside of the organization. Remember, if the employer is confident about the merits of the case, it should similarly not be difficult to put that evidence before an impartial chairperson. The unfortunate thing that most often is that you get line managers that are high performers. The moment they say they don't trust a particular employee, that's it. You are now at the backbone, to the extent that the employer may even decide on the basis of the say-so of a high-performing manager and just terminate your contract. And in that instances, you'll have to seek legal advice. Either you approach the courts on the basis of the unlawful termination of your contract, or, which is my best option, is just to join the queue and be at the CCMA, do the normal unfair dismissal referral, and wait for a set down and until the adjudication by an arbitrator. There may be instances where that right has been waived for instance, where the employer and the employee have agreed that they will refer a dispute to private arbitration, or they will make use of an inquiry by an arbitrator, which is a section 188A, capital letter A. It's a very famous process, often utilized by senior managers and senior executives.
Okay. Osborne, thanks very much indeed for clearing that up for us. Thanks so much. Always good to get some of this legal insights from time to time in the issues of labour. Thanks so much for your time.
It's my pleasure, Peter.
All right. Okay. So that was Osborne Molatudi, who's a labour law expert, and giving us his thoughts on that. And I just wonder if not playing launch was a breach of trust in the South African public, Palesa.